Since I feel like you introduced yourself already, or Alex introduced you, I'm going to let you just do your thing. If you just start talking, they'll stop talking. Just track your time.
All right, good morning, everyone. I'm NJ from New Jersey. You may know us in New Jersey from this. You may know us from this. And for the love of all things holy, you may know us from this. But more recently, and much more proudly, you may have heard or may know us from this. New Jersey's efforts around Belgium. About, that's 2 years ago now, I can't believe it's been that long, we started a process in New Jersey to change the landscape in our state in order to move to a system of pretrial justice reform. It involved the repeal of a constitutional amendment that entitled people to a constitutional right to have a benefit. It required collaboration between people from our office, the Attorney General's office, law enforcement community, all sorts of constituencies to come together and to create and map out what pretrial justice reform could look like in the state of New Jersey. It was sort of a Herculean effort that happened a lot differently than is happening here in Harris County. And I think with a lot more sort of planning and involvement of all sorts of constituencies. But here we are, 6 months into it. Our new law took effect on January 1st, 2017. And what we have seen so far, if you asked me a year ago when we were going around training our lawyers and training the judges on pretrial justice reform, I would never believe that we would be where we're at right now. But we have seen a 30% reduction in our jail population. We have detention rates in the mid-teens. We were expecting with our system of pretrial detention about 20% of our clients being detained, which is far fewer than they were. They're already recovering around 15%. We have 5 people in New Jersey on money bail since January 1st, 2017. 5. Yes, so I can still say it's happening on one hand. You can see the angry in that state judge. Makes you have to go to the other hand. So there is a place for money bail in our system. We sort of have this escalating system where the judge has to be satisfied that there are no conditions of pretrial release that will assure the defendant's appearance in court and ensure that he won't reoffend before they can go to money bail. And at that point, the prosecutors are told to ask for detention. So that's very much sort of a collaborative effort. We've had a lot of victories, early victories, and we held up and I was allowed to wear this. I didn't do too much. So I asked our John W. Air Traffic Control and graduated there. And we have seen varying judicial approaches. We've seen some prosecutors' offices that sort of over-moving to detain people, and the judges keep them in check, and vice versa. So we're starting to see sort of a leveling out. After about 6 months, everybody's been trying to forget who's going to be detained, who's not, and what kind of conditions people are going to be released on. But we have had our share of challenges. Educating the judges is a huge challenge for us. Our judiciary was on board with this, with maybe a little bit different than their magistrates here. But we have also started to educate our judges through the manual that we created, and you guys are going to have a similar manual. We gave that out to everybody. We didn't keep it for ourselves. We gave it to the entire pretrial justice community, and it contains a guide to pretrial justice reform in New Jersey. They closed John Smith, accused of burglary, out on the street because of bail on their Facebook pages. This article, this was a photograph, in a magazine, and if you look in really tiny print, it says, "Judge releases man from handcuffs in the courtroom, stock photo." As if judges are coming off the bench, taking off your handcuffs and going, right? And my favorite, personal favorite, is the bail bonds industry in New Jersey has a Facebook page, and this is their profile picture. Every night is close. And when you talk about what's, when you talk about what's kind of how this trickles into the court, because you may say, well, you know, I'm a defense attorney, I'm going to be working in court. What's happening is we have a huge media presence in our courtrooms. They're watching what we're doing, they're following cases, they're following the appellate cases. You will see, particularly where you are in a county within a state where this is happening, that you're going to see a lot of eyes on you, a lot of eyes on Harris County, not only in the state of Texas, but across the country. How is it working? Who's getting out? What are the arguments the attorneys are making? We get press calls every day on individual cases of bail reform. So be ready for that, and we're going to talk a little bit about how you can kind of deal with all of those influences today. So I say those things so that you're aware that it's kind of not just you and your client. There's going to be a lot of influences around you, kind of swirling around this new process as it starts to take place. But the best thing I think you can do to prepare, and we're going to talk this morning together about client interviewing, and some of the stuff is more about traditional client interviewing and how you can apply that to the setting that you're going to be going into, where you have like a crazy short amount of time to interview a client and get done what you need to get done. But the two things that you can do are, one, very quickly build a partnership with your client in that initial meeting, and two, develop a theory of what I've been calling, when I teach people, a theory of freedom. Not necessarily a theory of the case, although it's closely related, and I know all of you love that you have to use a theory of the case, right? So this theory of freedom, this theory that tells the judge why they should release your client with little or no conditions, with little or no money bail. And we're going to talk. And all of that means taking what you learned from your client partnership and your theory and wrapping it in the language of a good story that you can tell the court and that will convince the court that your client is different from the watch of every person that comes in front of me. So how do we do that? So there's like 7 steps in this culture. We're going to kind of go through these over our time together. One is you need to know the public safety assessment score and know what that means. You will have more training on that. I'm going to touch on the basics of the PSA in a moment. You're going to need to build a relationship with your client really fast, super fast, at a time when your client is probably least likely to want to engage in relationship building with you because they're in crisis, they've just been arrested. You want to gather as much detail about the client as humanly possible in whatever time you have. Identify the legal issues. Is this a case where you're challenging probable cause, or is this a case where you're just arguing that this person should be out, and on what conditions? Separate the legal issues, and we'll talk about what that means. Constructing a plan of action of what you're going to do in the short time that you have in the morning before you go in front of the magistrate, and then finally develop that theory of freedom that we talked about. So I want to touch just a little bit on the PSA, and obviously I'll give this caveat because we thought we might know a little bit more about the PSA before we came here today, that anything that you learn after this, just apply that, right? If I say something that later proves to be untrue about the PSA in your county, just replace that. But I've seen Dr. Van Nostrand, the person who created the PSA, speak on a number of occasions. And there's one thing that she always says that really, really resonated with me when I was trying to think about how to teach attorneys and prepare attorneys for this new system. And that's that the PSA is a tool. It's part of the process. It's not the process itself. And we really have been fighting in New Jersey to stop the natural sort of inclination of judges and prosecutors to say, well, there are 3-3 on the PSA, and therefore these are the conditions that apply. No,
The PSA is there to help you. The score on the PSA is there to help you kind of assess somebody's risk of failure to appear, their risk of recidivism, but it doesn't tell you everything about a person. It's just kind of a starting point. So it's very important to keep that and remember that keep that in mind that the PSA is not a replacement for your advocacy as lawyers. The PSA is going to tell you three things. It's going to tell you your client's risk of failure to appear on some numerical scale, and it's going to tell you whether your client is likely to commit a new offense on some numerical scale, and if they are going to commit a new offense, if that offense is likely to be violent or not. Those are sort of the three things that PSA measures. And when you get into court, you will have access one way or another, and I'm not sure how or when, but to that PSA score. You'll know how that score is calculated, and you'll have that score probably, and I can't say for sure, but probably before you meet your client. And again, that score is just a score. It's just numbers. It shouldn't be the be-all and end-all. So what I suggest that you do when you get that PSA score and you get the PSA information, the first thing that you do is look at those 5 things. Look at how many convictions your client has and what are they for. The length of the sentences for the prior conviction. Whether they have any prior bench warrants, pending charges, and the presence of absence of information contemplated by the PSA. For example, in New Jersey, somebody's juvenile history is not included in the pretrial risk assessment score. So what that means is you could pop up a 0-0, right? Genesis, I could get her run her record. I didn't mean to pick on you, but you're the only person whose name I know. Genesis, she could pop up as a 0-0, but when you look at her juvenile history, she has 7 prior juvenile delinquencies. So our prosecutors are allowed to argue that even though it's not factored into the score. So there will be things that are factored into your score, things that aren't. You need to know those so you can look at those. But I always suggest to people before they go into your meeting with your client, you kind of make a list of these things because you don't want to waste time with the client talking about things that you can get from the PSA document. You will have precious little time with your client. And these you will find when you get your training on the PSA become very important in terms of the calculation of the score. So for example, you want to know about the bench warrants because you may want to say to your client, I see you have 2 bench warrants. Tell me about the circumstances of these 2. Because it might be a mistake. Maybe it was one where he went to court in the morning and came at 12 and the judge bench warranted them, right? So that's very different than I was on the run for 3 years. So putting context to some of these can help you later when you go to attack the score. And then you'll be able to meet your client, right? So after you see what you can learn about your client on paper, you'll be able to meet with them. One of our challenges and one of the things that we found very difficult about kind of preparing lawyers for this new process is the place where meeting our clients is very different. And I don't mean physically, I mean mentally, right? When you talk about meeting clients where they're at, we're meeting clients right after they've gone to jail. We meet them within 24 hours. They have to go before the judge for first appearance. And although you might be thinking about how you do your bail argument, they're thinking about their wife. They're thinking about their job. They're thinking about their children. They're thinking about things that are not, related to the information that you need right now. They're also thinking about something else. It's a new system for you, and I know in New Jersey, we spent a lot of time talking to each other about bail reform, talking to lawyers, judges, every constituency, but nobody told our clients. So we wound up at the very last minute, and that's shame on us, sending out a letter to our clients saying, this is a new system. So, because you had clients coming in going, come in and go, tell me what my bail is, what do I have to post so I can get out of here, I'll call my bondsman. And like, sorry, it doesn't work that way anymore. You might be detained. Well, I don't want that, I'll just post the bail. There is no posting of bail, right? So explaining this new system, whatever your new system is, to your clients is going to be critical because some of them have been to this show before, right? They've been down this road before. So, and you might say, that's all right, I'm super lawyer, I can handle all of this, right? In my short client interaction, I'm going to handle all of this. I'm going to be able to tell them what's what, get the information I need for the bail argument, get in and out of there in the 10, 15 minutes. It's a lot. And I'm going to suggest to you that it requires sort of a rethinking about the way you engage with clients, and we're going to talk about that. But I wanted to talk about sometimes how we engage with clients now and get you to think a little bit about that.
Hey, I'm trying to help you here, man. Now, if you just tell me who your supplier is, I think this can end very well for you.
What are you doing, detective? What are you doing talking to my client without me present? You sneaky Pete? Which is which? What did the academy hire you right out of the womb? You guys get younger every... What'd you say to Babyface, huh? Did you say anything stupid? By anything stupid, I mean anything at all. Look at you, mouth open, vocal cords of Twitter. We'll talk about it later. Right now, you out. 10 minutes ago. Go on. There are laws, detective. Have your kindergarten teacher read them to you, right? Go grab a juice box, have a nap. Go on.